Hello, my name is Susan Graham, and welcome to the Beyond Retirement Learning Series. I have a business called Senior Edge Legal, and what we do in our business is focus on people who are retired or anticipating retiring, create a safe and independent future for themselves and their families. Today, we're going to be talking about give a priceless gift to your children and protect their inheritance from predators. You know, this is something that's a concern to a lot of people. Rather than giving an outright gift to their children, they may want to make certain that it's protected for them. I want to give you just a little information, a little housekeeping before we get started. The first thing is this will last less than an hour. And if you have questions, I'd be delighted to answer them, but please fill in that section on your screen that talks about chat. And make those questions general, please, because I'm prohibited ethically to answer specific questions because I don't have enough time to talk to you and ask all the background information I need to answer correctly on specific questions. Your goal, I know, is to get information, get an education about this area of the law. And that's my goal as well, to give you that information. In addition, I have a second goal, and that is to encourage you to schedule an appointment with me to talk about your own specific circumstances. We'll talk about that a little bit later because there'll be a survey form that comes up and you can indicate if that's one of the things you'd like to do. I have to give you my lawyer disclaimer. This is general information. This is not legal advice. And I'm the technology person here. There's no way, I love being a lawyer, but I'm not great at technology. So if I have a couple of pauses here, that's because I have no helpers and I need to do this. Okay. When we do estate planning with people, what we're talking about is helping them paint the picture of the future they want. Most of my new clients come to me because they're concerned that there might be a future crisis and they don't know how it's going to be handled. They don't want to leave a mess for their family. They're worried about family dysfunction. They're worried about running out of money. They're worried that they're losing their memory. A lot of different things. So what we do is help them paint the picture of the future they want and actually help them accomplish that. So let's get on to today's topic about giving a priceless gift to your children. And that means that the inheritance they receive from you will be protected from predators. So who are those predators? Well, if you have a married child and that child gets divorced, which unfortunately in this country is about a 50% rate, it's possible to set up your estate plan so that your child's divorcing spouse does not get a penny of the inheritance the child received from you. In addition, people, this is life in America. There are creditors out there. And if there's a lawsuit that results from owing a debt, for instance, somebody gets in a car wreck and it turns out it's their fault. They have insurance, but it's not enough insurance. It's an extra $100,000 that's owed. That creditor that has a lawsuit and a judgment against your child cannot reach and grab that inheritance that the child received from you. There's also bankruptcy issues. Again, the inheritance they receive from you can be protected from bankruptcy. And lastly, unfortunately, a number of my clients have children and grandchildren who have drug and alcohol problems that are pretty severe and make them really not capable of handling their finances. And those are another group of people that we can protect the inheritance. Excuse me. The usual way of giving an inheritance is just to give it to somebody. There's no strings on the money. They just spend it, do with it whatever they want. But what we're talking about is something different. We're talking a better way for many families is to make sure that the inheritance that goes to that child is actually going to stay intact and protected from the predators I just talked about. And one of the ways, of course, you can say, well, I'm not even going to give you the inheritance. I'm just going to disinherit you. Doesn't feel very well for the child that you've just done that to. So they're not getting the $100,000 at all because they've got all these other predators ready to grab that money. Sometimes people say, well, yeah, I'm going to disinherit that child, but I'll give that $100,000 to another child in the family and require that they use that for the benefit of the disinherited child. That's a nice idea. But that's got a lot of problems with it. First of all, the disinherited child is going to be really irritated that they have to go to the other one and ask for money. And it could be that the trusted child won't give the money to the one who was disinherited, because it's their judgment call. And as a matter of fact, they can decide never to give any money to the disinherited child, because it doesn't belong to that child. It belongs to the one you gave it to, the trusted child. And then the trusted child could have financial problems of their own, and poof, the money goes away. So that's a nice concept, but it's really not practical for most families. The way that I'm going to talk about today is actually a trust, an irrevocable trust. But don't care about that language. It's just an asset protection trust for the child. And how does this work? Well, you have to have a formal estate plan. You have to have something in writing that says what you want. And you say, it's like you have an empty shoebox. And you say, when you die, you create the shoebox before you die. But basically, it says when you die, the money that's going to go to that disinherited child, excuse me, not the disinherited child, that $100,000 to the child that has these problems now, or the potential for those problems in the future, is going to go into an irrevocable trust. And it's basically empty during your lifetime. I mean, it just sits there. But when you die, then the inheritance will go into that trust. How it works is, normally, in many circumstances, people say that that particular child, so I'm going to call that child Sam. Sam can be his own trustee, his own money manager. So the $100,000 is going to go into Sam's trust. That trust will have a tax ID number. You don't have to worry about this. This all happens after you die. And so it's not going to be Sam's social security number. It's a separate number. And the $100,000 that goes into Sam's trust, asset protection trust, is going to be titled in a bank account or a brokerage account in the name of Sam, trustee of Sam's asset protection trust, with the tax ID number 123. That's cool. That means that the money that's in that trust is not going to be included as an asset during a divorce. The spouse would have no claim or no interest in it. If Sam's getting behind in his bills, his creditors cannot reach in and take, if he owes $20,000 for a medical bill, they can't say, Sam, you got $20,000 in that trust, give it to me. It's just not enforceable. Same thing, if he gets a judgment against him because he was in a car wreck, as I described, and there's $100,000 that's owed, and there's a judgment, a court order judgment against him, again, they have no ability to grab that out of that trust. And if Sam ends up in bankruptcy because he has serious illness and a lot of medical bills, he gets laid off work, the economy goes upside down, as it has been in the last couple of years, and he can't keep up with his payments, the bankruptcy court cannot take that money. So that's pretty fabulous. Now you can have Sam be his own trustee, or in an alternative, you can have some other trusted individuals or a professional be the trustee. A professional would be like a bank trust department. You can even give the child, Sam, the ability to change the trustee. So if Sam wants, he can say, no, I don't want to be the trustee, but I nominate these other people to be trustees. While Sam's alive, under most terms of these trusts, he can take the money out whenever he chooses to. But if he takes the money out, so let's say he takes out $50,000 because he wants to buy a new vehicle. That's cool. He takes the $50,000 out and he buys a vehicle in his name, Sam. It's not in the name of the trust. It's just Sam's individual name. Well, when he takes that asset out of that trust, there is no protection for it. Okay, it's Sam's. It's not in the trust anymore. It's Sam's. And that's fine. Again, we don't want a car in a trust like that because of the liability associated with the car, but that's fine. Just recognize that there's no protection for the assets that are pulled out of the trust. And if he says, oh my God, that was stupid, I shouldn't have done that. He wants to sell that car and put now $45,000 because it didn't sell for the full 50 back in the trust. He can't do that. That's tainted money. You can't do it. Once it comes out and gets in Sam's hands, then it no longer has any protection. But Sam can choose the money that's in that trust. He can choose how to invest it. He can certainly just leave it in a checking account. He can also use that to buy a house or a cabin or invest it in stocks and bonds, a brokerage account. He can do all kinds of things. He can buy gold bars. Now, gold bars don't have title, so what he's going to do is have a safe deposit box in the name of his trust and put the gold bar in that trust or in that safe deposit box. The other wonderful thing about that is, again, the house and the cabin and the brokerage account are protected because they're in the name of this irrevocable trust under that tax ID number. And somebody is the trustee, whether it's Sam or someone else. But also for IRAs, retirement accounts that are inherited, if the trust is named as the beneficiary, Sam's Asset Protection Trust is named as the beneficiary, then the balance, that full value, so let's say that IRA is $50,000 and it's in the trust, that also is protected from bankruptcy. If that IRA goes to Sam directly, no, there's no protection. So if Sam gets into some financial pickle, his creditors again can take all of that money from that IRA. It's also, when you have a trust like this, so when you die, you say, whatever Sam inherits from you, the parent, is going to go into this asset protection trust. It makes it pretty easy for Sam when he's talking with his wife about it and saying, I'm keeping this separate. It's much easier to have that conversation and say, this is mom and dad's money, and this is the way they choose to handle it. It wasn't me who made this up, it's them. And it was important to them to keep it in just my separate property. And also, you, the parent, would say in that trust, when Sam dies, where the money's going to go. So you could say it goes to Sam's children or your other children or grandchildren. You can also be restrictive and say it has to stay in the family. It cannot go to in-laws or to some total stranger. You could give Sam the power to say where it's going to go when he dies. And you can make it as broad as you want. So he could make it go to his wife or a charity, or another friend. But you could also limit Sam's right to say where it's going to go, to say it has to be in your family. It has to stay in your family. You can say the bloodline or the adopted people. Now, let me show you how this works. This is an asset protection trust, okay? Well, you owe me $100,000. Give me the $100,000. There's $300,000 in there. Give it to me. No, they're not going to give it to them. They can't open it. That's why it has this lock on the front. But we lawyers are clever, and it wasn't me, the cleverest, the smartest one. These laws have been around for a long time, and they were designed for the ultra wealthy people, and now it's trickled down to the middle class. So there's a trap door at the bottom. So if Sam wants to take the money out, he can take it out. There are 4 magic words: for his health, support, maintenance, and education, which sounds like silly, that they really are the brick wall between Sam and the rest of the world. But he can take the money out whenever he chooses to go buy a new car, to go on a nice vacation, to give away to a charity or to one of his kids, whatever. But when somebody's knocking on the door saying, give me the money, he's going to say no. And they can't force him to open up that door. Okay. How do you make this kind of decision a reality? That's pretty easy. You have to do something. You cannot just talk about it. You must go through the formal steps and have a written plan on how this is going to be. And again, in my practice and my experience, the easiest way to do this is make one trust for Sam, again, one shoebox to collect Sam's money with all the terms in there. And then also, if you've got 3 children, make a separate one for each of those 3 children. Because when you're dead, if you don't have them separate out into separate entities, Sam doesn't want his brother and sister to know what he's doing with the money, whether he's being smart or stupid, on how he's investing it and how he's distributing it and where it goes when he's gone. He doesn't want to share that with his siblings, and the same for the others. So it allows them to operate independently. In addition, Sam can control in there. If you give him the right to say where it's going to go when he dies, and you give him the power to say who's going to also manage the trust. The money manager of a trust is called the trustee, the one who can sign the checks and decide how it's invested and when to pull it out and so forth. And you can name some alternates to Sam if you name Sam initially, but you can give Sam the right to change that. Now, for the ones that have drug and alcohol problems or are in bankruptcy, oftentimes there's a trigger language in there that says, no, they can't be their own trustee. Again, we're trying to throw up another brick wall to make it impossible. I mean, it shouldn't happen anyway when Sam is his own trustee, but to make it extra hard for any creditors to get at that money, we say when he's in financial pickle, then somebody else, an independent trustee, is going to be the trustee, so that it's not possible for creditors again to get at these monies. So you have to, when you set up these trusts, you have to have a formal written document that meets all these requirements and many other things that you don't really care about at this particular point, but there's a lot of details in there. And that has to be part of your estate planning package. And then it's okay. It just sits there, like I said, with an empty shoebox. It fills up when you're gone. Occasionally, I have clients put money in while they're alive. The first time I ever did that was I had a gentleman who was a client of mine, and he had a daughter with 3 young children. The daughter was in a messy divorce, and he was very concerned that the daughter and the 3 children would have no good home to live in. So he bought a house and put it in that trust. He stayed the trustee for the rest of his lifetime. That house did not get considered in the divorce proceedings and was not on the table for anything to be talked about. And then when he died, more money went into that trust and the daughter became her own trustee. You can do this for your children. And this is all legal magic, but basically what we're doing is we're pretending that the money that's in that trust, I say money, the house, the cabin, the brokerage account, whatever it is that's in that trust, after you die, still belongs to you. Okay? You're called the grantor, the trust creator. You're the ones who started out, and it kind of officially still belongs to you, even though you've been dead for decades at this point. This was established, as I mentioned, for the benefit of very wealthy people. And the law has been consistent in this area for a long, long time. So I don't anticipate that it's going to change. Of course, I don't have a crystal ball. I do have crystal balls. I actually have 2 of them. And my employees tell me that they're broken, and they absolutely are. They don't work. But nonetheless, that's my prediction of the future. I think it's highly unlikely this area of the law will change significantly. So if you do nothing, which is fine, that's most people's approach to estate planning, there's no protection for your children. They cannot do it for themselves. They cannot say, Mom and Dad always wanted to do this, so I'm going to take the $100,000 that I got, and I'm now going to put it in an irrevocable asset protection trust. You can't do it. The law doesn't allow for that when it's your very own money. So why don't people do this? Why don't people set up this kind of estate plan to protect their assets for their children when they're gone? Mostly because they just don't think about it, or they say, well, I'll get to it some other day. And what I'm talking about is taking the opportunity to paint the picture you want for yourself and your family, not only now during the good days, but God forbid, if you become incompetent, mentally or physically can't handle things, who's going to do that for you? And the day you're gone, a guarantee for each of us. So a lot of people don't do it because they think it costs too much. So let's talk about that. You know, what do you think an estate plan, a thorough estate plan that covers not only the good days, but should you be disabled or the day you die? What do you think that should cost? You know, if you look at value versus the price, I looked up today what it costs for a really nice dining room set. You know, this is a holiday season, and now thankfully, because the pandemic has lightened up a little bit, people are getting together again. Now, I happen to have inherited a dining room set from my family. And it's a very large table with many leaves and a number of chairs. And I looked at what they cost. You know, for one with 8 chairs, it ranges from $1,500 to over $20,000. Now, you know, the $1,500 one is going to have a veneer on it. It may not even really be a decent veneer. It may be a picture of a piece of wood that's pasted on something. And it's not going to last very long. It's not going to hold up if you keep wiping it down, because eventually that veneer is going to crack because it's too hot or it's too cold in the environment, or you've just wiped it so many times it's just kind of wearing through. The other thing is it may not hold heavy stuff on the table. When you have a large dinner, family dinner or gathering, oftentimes there's really heavy platters that are placed on the table. So you want to be sure that that lasts. So if you get a solid wood dining room set, again with 8 chairs or more and enough leaves to be able to extend it for large gatherings, you're looking at the $20,000 plus. But that $20,000 one, you're going to hand down to your family and they're going to keep it and you're going to maintain it nicely as well. How does that relate to estate planning? Well, our clients are not going to get the veneer version. I can assure you that. We won't do that for our clients because we want to have it be flexible so that it goes through any disability that occurs as smoothly as you can make that happen. And I'm not talking about just a progressive disability. I mean, you've been around people in your family and your circle of friends when somebody, oh my gosh, all of a sudden has a stroke or a heart attack, or something happens, they got a really bad flu and now they've got dementia, and they can't take care of themselves. They can't make enough appropriate decisions to manage their life during, not only for their finances, but their physical well-being. So we want to be certain that our clients can get through a disability as smoothly as possible and also avoid the court system at death so they don't have that at expense and oversight and their wishes are actually followed. Most estate plans, the average estate plan is primarily death focused and they're a package of documents. You don't know necessarily that those documents are going to work until you're gone, and that's a little late, or you're incompetent, you can't change them. In our office and Senior Edge Legal, we set up a plan that works when you need it to protect you, your spouse, and your children. And our fees are in the range between $5,000 and $15,000, depends on what people want to do. So if that works for you, you may want to partner with us to create the plan that fits for your family. Now, before I go on, let me see if you have any questions here. So let me look at that. Yes. Oh boy, this isn't uncommon. My children don't talk to me. How will you find them when I die? Well, let me tell you, that's not that hard. You might think it's hard. First of all, when you set up an estate plan in our office, we have contact information for the people that you are expecting to rely on to be the trustee or the personal representative or your financial power of attorney. So we've got contact information for those people. If truly, and those people are part of your circle, so they should have that information. You should have shared that with them if you didn't share it with our office. The other thing is there are actually companies that you can hire to track down people. If your children truly have left the family and been estranged for decades, it's still possible to find them. At least in my experience, in the few times that's happened, yes, it costs quite a bit of money. And the law requires normally that we have to spend at least 3 years looking for them. And then we can finally say, Judge, we've tried and we can't find them. But if you really have children that don't talk to you, then you need to talk with me or another attorney of your choice to decide how you want them to be dealt with. If you intend to truly disinherit a child, I'm talking just a child, not a grandchild, not a sibling, but a child, then it's important that you say in your papers, I intentionally make no provision for Sam. You don't have to say the reasons why, you just have to make that statement. Otherwise, the law says Sam can come forward and say, oh, they just forgot me and I'm entitled to a share. So that's really an important aspect, and that's something you need to talk to your attorney about. Oh, this is an interesting one. My children need money now. Should I loan it to them or gift it to them? That's interesting. And that's something that came up in my office this week. I had a client whose son said, Mom, I really need 200,000 and you've got plenty, and you're not going to need it. So why don't I borrow it from you? And I'll sign a promissory note, and I'll give you security against the equity in my home, and I promise to pay you at 6% interest and so many dollars each month and until it's paid. And if I don't get it paid off, it'll come out of my share of the estate. And Mom had and has 500,000 in cash and other investments. I mean, this is just cash. It's sitting in a savings account. I talked to her and I said, you can do the loan, and that's fine, and at least you'll have security in case he doesn't pay it. But are you ever going to enforce that? Are you ever going to turn around and say to your son, hey, you haven't met the monthly payment you're supposed to pay, so I'm going to now foreclose on your home? And the answer is no, she's never going to do that. So a much simpler way, and for everybody to be happy. And she wants to help her family. Her son gave her a good explanation about why he needed that. Just give him the money, but adjust the estate plan to say, I gave you $200,000 to Sam or whomever this child is, and that should be considered part of his inheritance when I die. So his share will be adjusted so that if it's equally among the three children, it'll still be equal. But on Sam's side already, there'll be a $200,000 amount, and then the extra money to make it equal among the three kids. So there are, every family is unique. And I don't know about you, but pretty much every family I come across is what I would call dysfunctional. I can compete with the best of them for dysfunctional families, and we all can, unfortunately. I mean, this is just life. And so all those issues need to be addressed when you set up an estate plan, to be certain that you're balancing out what you feel is appropriate for yourself and the family or your loved ones. Well, let me suggest your next step. First of all, you've spent your time listening to me today and gleaning this and getting this additional information about estate planning and protecting your children's assets, their inheritance that they receive from you from creditors, the creditors being a spouse that the marriage is going not well and going to end in a divorce, creditors, lawsuits, bankruptcy, or destructive lifestyles that it's a tough world out there. So they really may have alcohol or drug problems or other serious issues. So what I suggest you do is, when this program is over, just take 2 minutes, okay? That's not a lot of time, and write down at least 3 steps you can take to accomplish your personal estate planning goals. They don't have to be long sentences. It's just 3 things that you think would help accomplish your and be activated by your specific planning goals. If you do that, if you write it down, you double your chance of that getting accomplished. There are all kinds of studies that show that actually happens. So don't just keep it in your head, write it down. Now, at the end of this meeting, there'll be a survey that pops up. And if you complete that, that'd be great. If you sign up for a meeting to visit with me, there's no charge for that first 30 minutes, and that's a $225 offer. If you sign up for that, one of my employees will contact you and ask a series of questions to see if we have a potential for being a good fit. And if so, they'll set up that appointment. If not, they'll refer you to someone who might be more appropriate to help you out. There are also free forms on our website. So you need to go to my website, and at the top, there's a resources button. Click on that. And then when you get to that page, there's a free forms. And there are a variety of forms, powers of attorney, health documents, other things like that that you may want to print off for your own circumstances. And lastly, if you would critique me or make a suggestion on for future topics, I'd greatly appreciate that. I have been doing this for a long time, and because of comments from people like you, I continue to improve. So I really would appreciate that kind of feedback. And when you fill that out, again, it'll come to my office. If you don't fill it out, don't worry, there'll be another one that comes tomorrow. There'll also be something that you'll receive a link tomorrow, not only for the survey, but also a link to this video. So in summary, I encourage you to plan ahead with an estate planning attorney, someone like me. As I mentioned, I'm a certified elder law attorney. I'm one of about 600 nationwide. And I really thank you so much for visiting with me today to learn about this part of estate planning. Thank you very much. Bye now.